You comply.
15th October.
Yes. In continue.
Number 37.
Yes. Yes.
Similar issue has already been dealt with before it commences the exam.
Yes.
May I pass on?
Yes.
The question involved in this matter is the jurisdiction of the RERA in relation to a project where occupancy certificate has already been applied for, my lord. My lord, this is the first one is a writ appeal arising out of a writ petition, page number 9, my lord. Same issues have been considered by this honorable court, my lord. My lords will find the single judge's order at page 9. My lord, the findings, my lord. My lord, the two issues that were framed by the court at page 16. In page 16, first one was whether the complaint of the second respondent before the authority was maintainable. And my lord, that has been answered. Going into the new tech judgment, my lord, at page 37, my lord, in page 37 and 38, my lord. May I be permitted to read that paragraph, my lord?
Yes.
May I, my lord?
Yes.
My lord, page 38 from the scheme. This is an extract from new tech, my lord. From the scheme of the Act 2016, its application is retroactive in nature, character, and it can be safely observed that the project already completed or to which the completion certificate has been granted are not under its fold and therefore vested or accrued rights, if any, no manner are affected. At the same time, it will apply after getting the ongoing projects and future projects registered under Section 3 to prospectively follow the mandates of the Act. The apex court at paragraph 40 considers what is an ongoing project and issuance of completion certificate interpreting the Act and the rules made by the state of Uttar Pradesh. At paragraph 51 of the apex court holds that the statute is not retrospective merely because it affects existing rights or its retrospection because of a part of the requisites for its action which would destroy or impair the vested rights. At paragraph 54, the apex court holds that its action is retroactive in character and can safely be observed that the projects which are already completed or to which completion certificate has been granted are not under the fold of the Act, and at the same time, apex court holds that it will apply after getting the ongoing projects and future projects registered under the Act. In the case at hand, it is Rule 4 which exempts the project like the petitioners. In the light of the judgment, the apex court and undisputed facts as narrated here and above, the order passed by
Full stop. The Learned Counsel for the respondent submitted that the said orders, the disobedience bracket, the disobedience of which is complained, dash, have been stayed by the Supreme Court. Special leave petition, Supreme Court by an order dated 14/8/2025. Asked in special leave petition, bracket civil, diary number 25308 of 2025. So accordingly, the present complaint does not lie. We dispose of the same with liberty to the complainant to apply afresh, to file afresh if necessary.
Number 72.
No, there was one minute, there was one, 82, just one. Just 10 minutes we have the other one.
Still number 82.
It was on the urgency first. Can I just assess the Honorable Court?
Yes, tell us what you've mentioned.
Yes, my lords. My lords, there's an award of 2017
Yes,
against me, my lords.
yes,
In 34, there was an absolute stay. In 34 was against me eventually. 37, there was a stay by this Honorable Court, absolute stay. Subsequently, the Honorable Court modified the stay by saying deposit the money. That was taken to Supreme Court. Supreme Court reversed the order of this Honorable Court by consent and said that let the 34 be heard afresh.
34,
Be heard afresh. So appeal was also not taken up. 34 be heard afresh. In the interim, my lords, they again moved to Supreme Court saying that please make an order for deposit of the money. The Supreme Court made an order saying that in case you have something to do with this sort, make an application, point out that they're disposing of the assets, and then court can consider the request. They never moved this application for the 34 court at all. In second round, 34 court held against us. We came to your lordship court on 25/4/25.
yes,
Appeal was taken by your lordship court. Honorable Court admitted the appeal for final disposal, fixed it on 7th of July. In the meanwhile, court told both the sides orally, which is on record, we should not proceed with the execution application until such time the court takes up the matter for final disposal. My lords, on 9th of July, in 7th July, my lords may recollect that the Honorable Chief Justice was around the time went to Supreme Court, my lords. So 9th July, the court was rising, the normal bench. A mention was made by other side, is that we are drawing our statement of our undertaking. The court did not make any order. That's when the executing court on 14 August directs us in execution application disclose my assets. Now, my lords, my difficulty is I'm a classified MOD manufacturer of ammunitions. I'm involved with many NATO work softwares. I have the writer with me. I have difficulty to disclose before the executing court. I can show it because it's in public domain. I cannot disclose many facts.
or show enough assets to satisfy.
I am, 10 times bigger today as compared to when the award was made.
So show.
The 10 times. So
Show
I can balance sheet, I can show your lordship court.
No, you show any
I can show the demos, no difficulty.
asset which does not for your.
Certainly not.
If you don't want some, if you file some doesn't require disclosure, don't disclose that. But disclose enough assets to cover.
Certainly, I'll do that. No difficulty, my lords. But my difficulty is that I can't even take loan from the banks because I have to make disclosure to the banks. I'm debt-free company, full of assets, and I am under the MOD surveillance directly, my lords. My servers are connected to MOD. I can't disclose anything to anybody until I get permission from the NOD, the Ministry of Defense. That's my difficulty, my lords. And all this while, as mentioned to your lordship court, there has been an absolute stay, both at 34 stage, 37 stage, the Supreme Court order, and so on and so forth. So, my lords, my request is today, I can show a balance sheet to my friend, whatever is available with me, my lords, immediately, not difficulty.
They're not interested in what you're doing. They're only interested in knowing that is there If they succeed, then which they have already, there'll be assets to satisfy the award. So you show enough assets to satisfy their award, and then even undertaking, you will not dispose it of without the permission of the court. That should suffice.
My difficulty is I can't make substantial disclosure to them. That's the difficulty.
Asking for substantial disclosure, you have an award against you.
Yes.
It's a money decree. You deposit it in court. We are not asking
No, my lords,
for
this-
what, from where
Sir,
you
on
get the
merits,
money.
whether I can,
You can keep all your sources secret, deposit it.
Because on the merits of the award, my lords, as my lords may kindly consider, I can demonstrate lordship court
34
that
is-
this order,
It's a money decree.
but nevertheless, my lord, the Supreme Court, the 34 court, 37 court, Supreme Court has granted unconditional stay in my favor, considering merits of the matter. I can demonstrate lordship court whenever the court grants me liberty. Right now also I can demonstrate.
The first round. Anyway, you are finished off here. We did-
Yes, yes.
Tell us. Yes.
Now kindly see one order of Supreme Court directly before
You
my
ask
lords
us
take
the
up the-
merits. You show us the merits, what the award is. What's your claim?
Yes, but kindly consider, my lords. My lords, kindly have a look at the contract straight away, my lords. My lords, I have filed this contract separately with volume 4 because in the compilation of the lordship bench, it was not legible. It's a memo of additional documents filed on 2nd of September 2025. I have physical copies, may I tender for consideration of your lordships. They are part of the record of the Honorable Court, of course, but
Yes.
this agreement is known as consultancy agreement
Yes.
between on Fund 8 2014 millers between the SAVI, which is the respondent before the lordship court. My client, the appellant AIS Avio, kindly see the second recital at page 61, whereas AIS is a wholly Indian MSME engineering services and manufacturing company with defense industrial license and Semilec MOD for laboratory for military aircraft airworthiness certification approval. AIS is also registered as 100% EOU unit with coaching special.
In terms of my lord's directions, we have filed the affidavit.
Yes, yes,
I'll just
yes.
take 5 more minutes, my lords, just through the affidavit. If my lords may kindly take my affidavit. We have, lords, we have reconciled to the question. Only request we are making is, in the affidavit, my lords, at the end of the day, 1 year's extension, my lords, to continue the existing system. And I'm also fortified, my lords, by recent judgment of the Supreme Court in the teachers' eligibility test matter, which I'll just place on record. Kindly see the affidavit, my lords.
At least be candid with us. Look at your para 3.
Please, my lords.
Process of appointing guest facility is not for the purpose of, is not for discharge of what is workload. It is for increased workload on account of increased information.
Lords,
These
that
are
is
regular ones. Look at your proportions.
No, that is because, my lords, in the state institutions, there is no cap. Universities, my lords, have cap. I have also explained in the subsequent paragraphs. The sanction intake in universities is capped, my lords, by the concerned universities, my lords, and the constituent colleges. But in state government, my lords, there is no cap. Any number of because to promote affordable education, any candidate, my lords, including free education, any number of admissions is permitted. So for a particular year, I might have, my lords, more than 100 admissions in a particular stream, my lords, in a particular college. In the next year, it could be 20.
Understand. Is your case that that your fluctuation is so much that even the sanction post sometimes that you have zero guest facility,
Sanction
guest lecturers in particular year? Let's assume you have an intake of 100 and you require your sanction strength for 100 is, let's say, 10 teachers. Or
it's like this. We get the concern of the court with regard to the sanctioned post being around 7,000 and we engaging 10,000. That we are sorting it out. But for the present,
not engaging 10,000. Your sanctioned post is 7,000.
7,000
and 20,000.
And I'm engaging 10,000 milots guest lecturers.
More.
10,000 more.
Yes.
Therefore, 17,000.
17,000 milots.
You're not engaging. So it's not your 7,000 and you are getting 10% more or 20%.
No, I'm not able to follow that.
But you are going 100% plus.
Please, milots, we are
So
going
it can't
100%.
be your case that this is only because of fluctuating workload.
No, milots, it is because of the.
I don't know who is saying this affidavit.
Milots,
He's saying, according to him, it's fluctuating workload.
so fluctuating in the sense, milots, beyond the sanction intake, it is, and it depends.
Obviously, the workload is beyond the sanction. That's why you are appointing it. There is no dispute, cavil about
No,
it.
milots, we have also, milots, para 6, we have said that we are taking steps, milots, for increase in the workload, for increase in the sanction strength itself. And milots, kindly see para 6 milots for a moment. Para 5 talks about the existing sanction strength.
Yes,
Milots, may I read milots?
yes.
Para 6. Further, it submitted that in the budget for the year 25-26, it's intended to fill up 2,000 vacant teaching posts in government first grade colleges, government engineering colleges, and government polytechnic. As per the said budgetary announcement, a proposal to fill up 652 vacant teaching posts in government first grade colleges has been sent to the finance department's concurrence, through the concerned administrative department. Hence, it submitted that presently the process for filling up around 652 vacant teachers posts is in progress. It's also submitted the proposal for creation of additional teaching posts is being prepared to be sent to the concerned administrative department for concurrence of the finance department. And depending upon concurrence of the finance department, recruitment for filling up additional teaching posts will be undertaken in a phased manner. 7 minutes. I respectfully submit that, as stated earlier, engaging guest faculty is entirely dependent upon workload on account of increased sanctioned admission. In this connection, it's submitted that in order to provide affordable higher education to students, thereby facilitating increase in gross enrollment ratio, the state is not only regulating course-wise fees of the students in general, but also giving fee concession, especially to girl students seeking admission in government degree colleges since 2007. In view of this aspect, it submitted there is quantum jump in enrollment in government colleges, thereby resulting in increased student strength. Para 8 notes. Further, it's also submitted that there is no fixed limit. There is no limit fixed for admission in government degree colleges, and the government has issued order in 2009 to admit all students desirous of pursuing higher education. On account of this, it submitted that there's steep increase in enrollment of students in government degree colleges, which has invariably resulted in increased workload, thereby necessitating appointment of around 10,000 guest lecturers for the academic year 24-25. It is submitted that as per UGC regulations, apart from the essential qualification of master's degree in concerned subject, a person desirous of teaching post has to additionally pass NET exam conducted by UGC CSIR, presently so-and-so, exam, or SLET, SCT conducted by state government, and exemption from passing NET, SLET, SCT is given to those who have a PhD. In this connection, it is submitted that the NET exam is conducted twice in a year, and insofar as KSCT exam is concerned, the said exam has been conducted in the following years. Then, my lords, we have given every year, my lords, almost every year it has been conducted. With reference to the reliance placed by UGC Council upon communication of UGC dated so-and-so, wherein at point number 2, it is stated that where the sanctioned posts are not adequate as per the teaching workload, the number of guest faculty to be appointed can be up to 20% over and above the sanctioned post. In this connection, it submitted that the said communication is addressed to Registrar of all universities regarding guidelines for enhancement of rates of honorarium of guest faculty, and it's not addressed to the state government. And as such, the said communication is not applicable to educational institutions run by the state government. Since there is a cap for intake in universities, the directions given in the said communication is liable to be applicable. But insofar as government degree colleges are concerned, where there is no cap or any limit fixed for admission as the intention is to provide affordable higher education, the direction given at point number 2 of communication dated so-and-so cannot be made applicable. If the state has to take action in terms of the direction given in point 2, then it is submitted that the state would be depriving deserving students from higher education. Further, it submitted that the entire financial burden arising out of the payment of honorarium to guest faculty is borne by the state government only, and UGC does not share said financial burden. As such, the state is empowered to engage requisite number of guest faculty, keeping in mind academic interests of the student in government degree colleges. Further, it is submitted that the Karnataka Examination Authority has issued notification dated 22/8/2025 for conducting KSET examination on 2/11/25. In view of this aspect and also in view of the fact that this Honorable Court has issued interim orders on various dates and 37 writ petitions filed by 1,145 guest faculty who had worked for the academic year 24-25 with prayer to continue them for academic year 25-26. The government prays that this Honorable Court be pleased to consider granting of 1 year time to those guest faculty who have not passed NET, SLET, SCT to obtain the same as a last chance. For this, the state undertakes to appoint only those persons who possess UGC prescribed qualification for the academic year 26-27 as guest faculty, and also it is submitted that non-UGC qualified persons would be considered for guest faculty only in those subjects having shortfall of UGC qualified candidates. So, my lords, one
They
submission.
want 1 year respite.
My only submission is this. I have also suggested, the state has filed a memo dated on 22/8/2025, where they disclose that they, but for 899 seats for which they have called for all others seats they have out of 10,303 posts that are there as per their own list, only in 6 subjects, 3 subjects, they have some deficiency, they don't have candidates. In another 3, only 1 or 2 posts are there, for that they don't have.
No, so for purpose of selection,
Yes, Lord.
you give them some leeway to say 1:1.5.
My only humble, yes,
There's 1 seat, there are 2 seats, so they can take in the zone of consideration 3 people. In other words, let's say suppose the number of qualified persons are only 10 and the seats are only 10, then everybody will sure shot will get it.
yes,
That may not be the best scenario. They must have some selection. Otherwise, they'll have no leeway even to select whom they want. So give a ratio for the first year. Only for 1 year.
there are 2 things, my lords.
Next year, of course, there's no issue.
My only submission is Honorable Apex Court, as latest as on 14th of July 2025, has said that state better follow. The very same regulation was under challenge in Punjab, my lords, and they appointed by having different methods than what is prescribed under the very same regulation, and the Honorable Apex Court has allowed.
No, we are only saying qualification.
Yes, qualification, my lords. My only submission is the time and again, Honorable Apex Court has held the regulations of UGC or similar body like AICT, where the regulations are coming out from the statute, the power given under the statute, my lords, the qualifications and the regulations should be on par, treated as on par with the act of the parliament, and even state cannot pass a legislation to deviate from that. That being the case,
Let's see where it said that.
that being the case, my lords, in this case, my lord, the issue was appointment of assistant professors by the state of Punjab. My lords, they have conducted, deviated from the procedure prescribed and conducted the test. Lordship, kindly, from page 13, the paragraph 39 onwards, my lords, a clear discussion is there. Lordship, got it?
Yes.
If I may, paragraph 40, my lords.
Yes.
Yes. Thus, officially, the 2010 UGC regulation were in force in the state of Punjab as they were adopted by way of incorporation and not by reference. The repeal of so and so, I would rather, my lords, 41, if I may persuade your lordship to see, because it is in detail, it has said, 41 says, my lords, doing away with the regulation to 2010 was also a last minute decision in January 2021, requisition of recruitment for 931 assistant professors and 50 librarians was sent by the state government to the commission. Then a meeting of the Council of Ministers was held on so and so in relation to the recruitment of additional 160 posts and assistant professors and 17 librarian, which had come up in 16 new government colleges, where the decision was taken to remove those posts from the purview of the Public Service Commission, so that recruitment can be made through a department selection committee, which were have already mentioned above. But what is significant here is that till the time the government had all intentions of following the 2010 regulation. Then, my lords, what was the requirement under 1.4? It is stated. Then 42 paragraph in the last line, in more recent judgments of division bench of this court, so in Gambia, it is held that UGC regulations have a mandatory character and are binding in all universities, state or central, that have opted to receive the financial assistance of the UGC under its scheme dated 31/12/2008, which later came up for consideration. In that case, what weighed in the mind of the division bench of this court was the fact that the concerned university had availed the above mentioned UGC scheme, and as part of the same, it had agreed to adhere to the regulations of 2010 and 18. In that case, as a result, the university was bound to follow the UGC regulations. In the Gambia case, my lords, the question was appointment of the vice chancellor. Rules that bring statute brings them in line with UGC regulation. This is what it was held. It is not in dispute that SP University is receiving central financial assistance under the scheme, and it is included in the state universities receiving central financial assistance as per section 12 of the UGC Act. Therefore, having adopted the UGC scheme and implemented the same, and getting the central financial assistance to the extent of 80% of the maintenance expenditure, the state government and UP University are bound by the UGC regulation 2010. The UGC regulation 2010 are superseded by the UGC regulation 2018. However, the eligibility criteria for the post of vice chancellor and the constitution of the search committee for the appointment of vice chancellor remains the same. Therefore, the state of Gujarat and the university thereunder, including the SP University, are bound to follow the UGC regulation 2010 and 18. In that, it was held that UGC regulation became part of the parent act, that is UGC Act, being a piece of subordinate legislation that is laid before both the House of Parliament. As a result, these would provide in case there is any inconsistency between a state legislation and UGC regulations. By the application of the doctrine of repugnancy, it cannot be disputed that UGC regulations are enacted by UGC in exercise of powers under section 26(1)(e) and 26(1)(g) of the UGC Act. Even as per the UGC Act, every rule and regulation made under the said act shall be laid before each House of Parliament. Therefore, being a subordinate legislation, UGC regulations become part of that act. In case of any conflict between the state legislation and the central legislation shall prevail by applying the rule principle of repugnancy as enunciated in Article 54 of the Constitution, as the subject education is in the concurrent list 3 of the 7th schedule to the Constitution. Therefore, any appointment as a vice chancellor contrary to the provisions of UGC regulation can be said to be in violation of statutory provision warranting a writ of quo warranto. UGC regulations are made under UGC Act, which was enacted by the Parliament under entry 66 list 1 to the schedule 7, whereas state government were under entry 25 of the list 3 of the schedule 7 to make the law relating to education. Further, it is to be noted that entry 25 of the list 3 is subject to entry 66 in list 1. Hence, law including the subordinate legislations, as in the present case made under entry 66 of the union list, would prevail over any law made under entry 25 of the concurrent list. 45, another judgment of the Honorable Apex Court is quoted, my lord. Then I may persuade your lordship to come to paragraph 48.
Yes,
My lord.
yes.
In short, we find that there is a total arbitrariness in the present selection. The memo of Council of Minister dated so and so shows that state wanted to recruit only 160 posts of assistant professor and on 17 posts of librarian through a departmental selection committee on an urgent basis, as these were for a newly opted college, open colleges. As we have already stated, even in those cases, the recruitment was to be made by following UGC regulation. Next, the 931 and 50 posts of assistant professor librarian, which were lying vacant in regard to the which requisition had already been sent commission, were added, and it was decided that sole basis would be a single examination. Similarly, my lord, if I may persuade your lordship to come to para 50, my lord. The state cannot defend such an arbitrary practice in the garb of policy decision. We have to keep in mind that these were the posts of assistant professor for which specialized body like UGC has prescribed a process for the selection, which includes appreciation of academic work of the candidate, his or her performance in Viva OC, amongst others. Just simple multiple choice question-based written examination cannot sufficient to check the suitability of the candidates. Even if it is, then also the present case, a sudden replacement of the time-tested recruitment process with a new process was not only arbitrary but also done without following the due procedure. Then, if I may persuade, my lords, 51, the next paragraph, all this goes to show that the intention of the authority was to conclude the exercise as quickly as possible, which though sought to be justified on the ground of expediency of filling up the post, undermine the selection by reason of no quantitative assessment of the candidate carried out. Then the judgment of the learned single judge was upheld. My humble submission is, it is not the first time. You know, there are several occasions, Lord, in respect of AICTE regulations also. Non-following of AICTE regulation was held to be wrong and they are mandatory, Lords. As back as in 2013 itself, Lords, Honorable Apex Court in the matter of Lords Pashwanath Charitable Trust and others, Lords, versus AICTE, a similar stand is taken in respect of AICTE regulations as well, Lords. If I may, Lords, page 401, para 28, the relevant, because before that all the judgments were discussed, my lord. Then para 28, your lordship got it, my lords. May I?
Yes.
We have already noticed that compliance with conditions for approval as well as regulations and provisions of the AICTE Act is an unexceptionable condition. Class so and so of the handbook approval process issued by the AICTE provides a complete procedure for change of location, etc. It contemplates obtaining of no objection certificate from the state government or UT administration and affiliated bodies concerned. The same clause also requires submission of the land documents in original and clearly provides that the same may be registered, sale deed, irrevocable government lease or a minimum period of 30 years, etc. by the authority consent of the government. Further, it provides that any plan, building plan for new should be prepared by the registration. So there the question was that, my lord. Then if I may request lordship to see para 31 in the next page, 402, thus view of the High Court that college has failed to comply with the requirement for grant of approval and had shifted to the new site without approval of AICT and other authorities concerned cannot be faulted with. Therefore, being no compliance with the legal requirement and binding conditions of recognition, the withdrawal approval by AICT can also be noted, not interfered with. Similarly, my lord, para 35, if I may persuade your lordship to see, it is the requirement of law that there should be strict compliance of the time schedule for grant of approval as well as admission without exception in excess of the powers vested in AICT under subsection 1 of section 23 of AICT Act. It had made regulations, namely AICT grant of approval for starting new technical institution, etc. Regulations that has given schedule. Then 36, my lords, it says that the similar line, it has said the regulation of AICTE having been passed by exercising the power under the Parliamentary Act, the same would prevail over. My lords, even the Gambi's case, my lords, which was referred to in the latest judgment in 2022, my lords, similar is the section. There cannot be any excuse, my lords, even for the state government to deviate from that. The submission made by Learned Senior Counsel and Additional Advocate General, my lord, I take serious objection to this affidavit for two major reasons, my lord. First of all, my lords, at para 10, they have said.
Continue tomorrow.
Much.
We have another bench at 4:45.
With the leave of the court. With the leave of the court.
Tomorrow at 2:30, my lords.
Serial number 71, I am mentioning to the Honorable Court. Serial number 71, wherein I have filed an application for extension of time to comply the interim direction granted by this Honorable Court. I have submitted the demand draft to the court and two demand drafts were submitted. One
Serial number
was
55, my lords. Serial number 55, my lords, we have set up an industry by obtaining case-specific permission. Gram Panchayat is not giving me permission, my lords. 18 crores, my lords, I have spent, my lords, on the industry. Any date this week, this month, my lord. Any date this month.
Serial number 68 and 69, I had an interim order operating in those matters. Inadvertently, it was not extended on 24/7/2025. We made a mention, my lord, but somehow inadvertently, the extension was not granted. My lord would be pleased to extend the interim order. There are execution proceedings pending in those matters.
Sixty-eight and
68 and 69.
Sixty-eight just said the Learned Counsel for the appellant submits at the interim order training and not extended on the last date of hearing. Based on that, the interim orders as was subsisting as on 24/7/2025 shall continue to the next date.
Serial number 50.
Give another date.
Serial number 52, my lord.
Yeah.
But
Final application was for restoration of the appeal. It will be taken tomorrow, my lord, because there is a resolution from the other end to auction this property. The challenge is section 14, my lord, of the Safety Act.
52 was. Fifty-two.
52, my lord.
52. Was dismissed.
Comply the
That's why we are putting it
Pending
tomorrow.
consideration of-
No, because the permission the court.
pending consideration of the applications for recalling, the council is permitted to comply the office objections.
That's why we immediately demand-
You do not do it, it gets dismissed, and now you say urgency.
That's why we come back.
You do it.
I was mentioning to the Honorable Court serial number
52 and so the learned counsel for the appellant is at liberty to comply with the office objections. Pending the consideration of the application for restoration of the fee. Within a period of 1 week from date.
I was,
19.
I,
From the other end to auction the property.
You can't help it. Look at it from 2024, you're not complying with your objections. We are not sure that we're going to even restore your appeal. It's not an automatic restoration of appeal after 6 months.
I was
This court by urgency, this kind of urgency in these matters.
submitting to the honorable court, serial number 71, serial number 70.
Give you a date.
Not serial number 62 notes, the particular Bar Council contempt notes. We have restored notes, we are complaining.
62 will dispose. 62, the
71.
My Lord will kindly appreciate, they have no regard for the orders passed by the honorable court. They are not filing complaints.
62, just say
Tears are rolling in the,
the 62,
what prompts them, my Lord? They do everything except implementing the order. They have scant
They've now
respect for the
implemented,
orders
na?
passed by the honorable
Now
court.
it is implemented now.
They have not implemented, my lords.
No, they have implemented.
Even as on today, they have not intimated that his name is entered in the resumption.
It has been done, notes. It has been done.
They never do
Yesterday,
that, my lord.
yesterday notes.
Let them file an affidavit.
Very well.
I will stop practice, my
Hand
lord.
over-
Why
hand
these
over-
direct tactics?
Hand over to the
Okay, we
Sanad.
handed over,
Sanad is handed over.
Sanad is handed over.
Shame and disgrace, my
Has
lord.
the Sanad been handed over? Has the Sanad been handed over to you?
Senate is handed over, but
That's
they
all
are
right.
not
Just take
intimated,
that.
my lord.
The,
Notes, DD, they're supposed to pay no DD
That
notes.
also in torn, my lord. They
They have got a DD
have
notes.
side of toilet.
Learned counsel appearing for the accused submits that the,
ಎಲ್ಲ ಹರಿದಿದ್ದು ಕೊಟ್ಟಿದ್ದಾರೆ ಸಾಹೇಬ್ರೆ. ಎಲ್ಲೋ ಒಂದು ಕಡೆ
ಬಿಡಿ.
ಬಿಸಾಕ್ಬಿಟ್ಟು.
submits it in terms of the order dated 23/8/2025. The Sanad was handed over to the complainant. And there is no impediment in continuing his practice. His name has also been
Restored.
stated in the role of advocate.
Please,
In view of the above, no further orders are required to be passed.
they were supposed to pay,
The same is disposed of.
they are supposed to pay no DD. No, they would, not return back the amount, notes, 7,75,000.
Had we said, we have written, look
And
at the
in
last
fact-
order. Now
Lord,
you
with
file
the-
your contempt, no?
No, we have not, so in fact, when he has got a DD notes, he has showed to us yesterday. Well, now he is in fact.
You file.
Now you
File
They
your-
want to have a pound of flesh. They got tons of money, my lords.
Well,
Because they let-
There is an urgency, my lord.